The next case to come before the court is Cessna versus Landers. We are, we're right on schedule. Gentlemen?
The appellation should be on this. Doesn't matter.
It really doesn't matter. The appellant will have 15 minutes to present oral argument and may reserve up to 5 minutes for rebuttal. I explained to counsel who was here before that typically we have 3 judges sitting on the panel. One of our colleagues was ill this morning and will review the video before we conference, and we'll take matters from there. So, if the appellant wishes to reserve time for rebuttal, if you'll let me know, I'm keeping time.
Thank you.
All right? We've read the briefs. We're ready when you are.
Good morning. Please the court. My name is Brian Barnard. I'm here on behalf of Joel Cessna. I would like to reserve 5 minutes for rebuttal.
Yes.
Your Honors, I believe we're here on a rather narrow issue in this case. I think the issue is, were oral loans time barred by Ohio's 6-year statute of limitations in this case? I believe the answer is no. That's because these loans were conditional. These loans were conditioned on an ability to repay. These loans involve my client Joel Cessna and his brother Noel Cessna. There's been quite a bit of deposition testimony as well as affidavit testimony, which is quoted extensively in our response brief, where there are factual issues regarding Noel's ability to repay. He did not make much money, about $10,000 to $15,000 a year, and his brother had not required him to repay until he was able. Now, instructive to the court in this matter is a case decided by this court, Oschlager versus White, and in that case this court said that when terms such as when able are attached to a loan or oral promise to pay, a conditional loan arises, and the cause of action does not accrue until that ability to repay comes to fruition. And in the Oschlager case, this court correctly determined that the ability to repay is a question of fact. It's a question of fact for a jury to decide. And in deciding the Oschlager case, this court cited Crawford versus Kramer, which was a case out of the 7th District, very similar to this case, and that case was also remanded by the 7th District for a determination on the issue of when did the debtor become able to repay the loan. And we think it's pretty clear here from the record, the deposition, as well as my client's affidavit, that this condition, precedent, which would have started the running of the statute of limitations, the ability of Noel Cessna to pay, did not happen until his death. Now, when he died, there was an interest in the farm that he owned, where he lived, and that became a source of ability to repay.
I'm sorry to interrupt, but was there any argument below on whether or not the debt was extinguished by his death? And to the extent that you're arguing that it was conditioned on his ability to pay, once he's dead, he doesn't really have an ability. It's a legal issue of whether or not the estate really is required to assume that.
Yes, sure. That was not raised below. And if we go back, I think this case, since it's a legal malpractice, it becomes one of those case within a case. Yeah, so we're also arguing back to the time of when the malpractice, we believe, occurred. And my client was the executor of his brother's estate, so he only had 90 days to bring those claims. And certainly claims properly brought within the 90 days would have had to be addressed by the estate, and by the court, and by a jury. If the court, probate court, did not accept Mr. Cessna's claims for loans made, he would have the opportunity to then present those to a jury. And what our argument is that he was clearly divested of that right by Lander's failure to file his claims in a timely manner. If the court is aware, that 90-day statute of limitations for an executor filing a claim is an absolute bar. So he lost any and all opportunity to even be able to present those claims to the probate court. And also for some clarification to the court, he was the sole heir under his brother's will. But however, in the years that passed after he drafted the will, or the will was drafted, Noel Cessna was married. So the spousal allowance came in, and she was able to take the first $40,000, and as well as the cost of administrations came out of the estate. However, our position is that after that, had his loans been timely filed, the claims made timely in the probate case, and accepted, which would have been an issue of fact that would have had to been determined then in the case within a case. Had he been successful, he would have been entitled to the entire balance of the estate, approximately $83,000 or so, as a general creditor. However, because the loans were not filed in a timely manner, the 90-day period of time was missed by Attorney Landers. It ended up that he had to negotiate the balance of the estate with the surviving spouse because his claims were never filed, so he wasn't a general creditor, and the statute of descent simply came in and applied. So he ended up getting about $41,000 when we believe, had his claims been properly filed and approved, he would have been entitled to $83,000.
So what do we do with the information that was before the court that he really came out better by negotiating a settlement?
Your Honor,
the court obviously bought that based on the attorney who was involved.
Your Honor, we believe that's incorrect. We believe that that attorney's email that's in question, I believe is what you're talking about, is incorrect. That's not a correct statement of the law. And there is some deposition testimony from Mr. Landers, I believe it's page 52 and 53 of his deposition, where he basically states that had Mr. Cessna been a creditor, he would have gotten the entire balance of the estate, $83,000. Now, the email says, I did better for you because I got 41. Well, he did do well for Joel, but only after Mr. Landers missed the deadline for filing the claims. So the $80,000 is gone, and what the email is basically saying is, I did well for you because I got you at least half of that, because technically it's all gone. Landers missed the deadline. So that's what the email actually means.
So it meant he did well under the circumstances.
Under the circumstances, Your Honor. And that, I think, is, again, something that needs to be hashed out at trial. Because these are all issues of fact. We would just submit that to the court.
Are you finished? Okay,
Yes,
you have
sorry.
5 minutes remaining.
Okay,
Thank you.
Good morning, Your Honors.
Good morning.
My name is Tim Brick, and I represent Bill Landers in this case. This is the first time I've had a chance to argue in this courtroom, and I consider it a privilege. It's a beautiful and impressive room, and glad to be here. The claim here is that Mr. Landers committed malpractice because he failed to assert these loan claims against his brother's estate. Mr. Landers did agree to assert one claim against the estate. It had to do with the $39,000 check that was used to buy a Mercedes back in 2001 or something like that. And Mr. Landers has acknowledged that he missed that deadline, the jurisdictional deadline to present that one claim. That was a mistake. He has owned up to it. But that's not why we're here today. We're here today because I think that Joel Cessna's loan claims against his brother's estate, even if they had been timely asserted, would have failed as a matter of law. That's what the trial court held here in this case, and as a result, Mr. Cessna cannot satisfy his burden of proving proximate causation. I don't want to spend a lot of time on the facts here, but there is just a few comments about the underlying probate court proceedings, which counsel touched on. Joel and Noel Cessna are brothers. Mr. Cessna is a stockbroker. His brother Noel was the car mechanic, and I think they were very close. They owned a house together, jointly, 50-50, or a farm. Mr. Joel Cessna apparently supported his brother in some fashion with these checks, and Noel named his brother Joel as the beneficiary under his will. So they were very close, and then Noel died unexpectedly in 2013. But even though Joel Cessna was named as the beneficiary, now there was a wife, and she elected against the will and exercised those statutory rights. And I think that caused a lot of tension and friction, and that these probate court proceedings were very, very contentious. And I think the record is pretty clear that Joel Cessna was willing to do whatever it took to get the inheritance from his brother's estate. And this started out as a claim for this Mercedes, which he had been driving treating like his own for many, many years, but it was titled to this auto ranch. Then it morphed into, well, I had $170,000 in loans. And then when that didn't work, then he pivoted to this, well, I was in a partnership with my brother, and I do believe that the evidence shows that he successfully used that argument to negotiate a very good settlement in the underlying case. So,
as your opposing counsel indicated, a very good settlement has to be seen within the context of when it was negotiated. It was negotiated after the deadline was missed for filing.
I understand that, and I think that that logic doesn't really apply here, because it's not like there was a mistake made and I had to take whatever I could get because of these loan issues. This was a totally new argument, 100% new argument. It had nothing to do with anything that Mr. Landers did or didn't do, and they used that to negotiate the settlement.
That what was a new argument?
This was a new argument that there was a partnership. And it had nothing to do with the loans. It's not like he had, that they were, well, yes, the loan argument is bad, but we'll take what we can get. They totally switched tracks to a whole new argument. And this was, these weren't loans. No, they weren't loans. Now I was in a partnership with my brother, and this $170,000 was a capital contribution. And that's why that evidence that came in and says, look, this is a better argument than the loan argument. This actually strengthened his hand, I believe, is our position. It wasn't a settlement made out of weakness, but it was a settlement based on a new argument that was actually stronger. So I do think that all that is important. There is an issue, I think, on the standard of proof. I think we all agree that the environmental network case applies, and that the case within the case, the plaintiff has to prove that but for this failure on Mr. Landers' part, he would have actually won in the underlying probate court proceedings. I will point out in the opening brief at page 7, there seems to be a disconnect with that logic, where Mr. Cessna argued that for summary judgment purposes, this court is supposed to assume that they would have prevailed. That's not the case, and I would like to talk about these loans a little bit. These were not traditional loans, like if I went to my bank, I would get a loan and they would have a contract and all that kind of stuff. Here, it's undisputed that these were oral. Whatever happened here was an oral agreement. There's no promissory note or anything like that. And I think that the evidence establishes that there were no terms at all. And that's really important, because there is the first issue that to be addressed really is whether this was a conditional loan or not. I mean, the undisputed evidence is, hey, for oral loans, 6-year statute of limitations, and there's no dispute that all these checks in the check register, whatever happened more than 6 years before Noel died. So I think Mr. Cessna testified in deposition repeatedly that there were just no terms. This was a very informal thing. There was no definite time for repayment. And I think, based on his own testimony, that means that the statute of limitations began to run when whenever these checks were written. And that was all more than 6 years.
Well, how do you respond to the argument that where, based on case law out of our district, that where the loans repayment is conditional, that it time does not begin to run until the condition has been met?
That I understand, but I don't think we get there.
Okay.
We don't get there based on Mr. Cessna's own testimony, where he repeatedly testified that there were no terms, there was no definite time for repayment. And the case law is pretty clear that that's not a conditional loan. So if it's not a conditional loan based on Mr. Cessna's own testimony, they're out. Okay? Now,
When you say his own testimony, you mean when he was asked, well, what was the interest rate? What were the dates? All of that. And he said, well, there weren't any.
Right. He said there were no terms. No terms. Very informal, which is not unusual since this was a brother-brother situation, but it undermines the ability to prove that they were loans that you were going to assert against the estate. So I think that's really where the case should stop, based on his own testimony. Now, Mr. Cessna understood, after we filed our motion for summary judgment, that that his own testimony kind of doomed him, so he came up with an affidavit, a pretty self-serving affidavit that is full of all kinds of, I think, conclusory allegations, but he says, oh no, this was a conditional loan. Even though he had testified in his deposition there were no terms, now he said this was a conditional loan based on when my brother could repay me. And I don't think that affidavit should be considered, because he's trying to create a material issue of fact here based on contradicting his own testimony. And we cite some case law in our briefs that says that you're really not allowed to do that. So I think that the case really should stop right there. Based on his own testimony, these were not conditional loans, and the statute ran before Noel died. Now, if I do want to address this idea that if the court wants to engage in this analysis, was this a conditional loan? Yes. It's still, the trial court's opinion should be affirmed, but we acknowledge that if it's a conditional loan, that the statute of limitations is impacted by that, and when is the ability to repay. So what evidence has been developed about that? Now, in his affidavit, Mr. Cessna has some self-serving conclusory allegation that I don't think is evidentiary, and he just says, well, my brother couldn't repay. He didn't have much money. But what do we know from the record? That he did have some ability to repay. One, he owned half the house with his brother, so he could have sold it to someone, he could have given it to his brother, he could have loaned against it. There was some ability to pay based on that. But more importantly, it has to do with this auto ranch business and what these loans were made for. And as explained by Mr. Cessna in his deposition, his brother Noel would come to him, I want to buy a car, I need $15,000. So he would write a check, and then Noel would get the car at an auction, fix it up, and then sell it maybe for a small profit, say a couple $1,000. And at that time, based on the inventory that was purchased with Mr. Cessna's note, he could have been repaid. And in fact, it was a very informal relationship, and sometimes he was repaid. Sometimes his brother would pay him a little bit here or pay him a little bit there, but it was a situation where the money that was being, quote, loaned to his brother to buy a car could have been repaid when the car was sold. But Mr. Cessna decided not to do that. It's his brother. He didn't want to really press him on the issue. And that's his own testimony again. So even under this theory that this is a conditional loan, I think that he would have the burden of proving, well, there was no ability to repay until he died, and that's simply not the case in the record.
I'm going to stop you at this point just because you're beginning to encroach into your 5 minutes that you wanted to reserve, but you're free to continue.
Well, just a little bit. So,
Go ahead.
But under this, just to kind of recap, we don't think we get to the conditional loan based on the fact that Mr. Cessna testified in deposition that there were no terms. that should be the end of the case. But even if you do get into this idea that it was a conditional loan, that the evidence is that there was an ability to repay, which would have started the statute of limitations, only Mr. Cessna chose not to press the issue. And while that's understandable because it's his brother, that dooms his case. So the statute would have run.
So when would the statute have run based on your argument that he had an ability to repay? At what date?
I think when the loans were made or when the cars were sold. And, I think he could have, like I said, he had some assets. He had a house. He shared it with his brother. That's in the record. The fact that Mr. Cessna wasn't acting like a true creditor against his brother, that's his decision, but it undermines the validity that he can enforce these loans.
Very well.
Thank you.
You know what? I just realized that I am in error. You have 5 minutes, but you don't have rebuttal, so you can keep talking for another 3 minutes if you wish.
Well, Your Honors, I did make my points, and I'm happy to answer any questions that you might have.
Thank you so much.
Okay.
All right. Counsel, you have 5 minutes remaining for
Thank you.
rebuttal.
Just some clarification here. First of all, on the partnership theory, I think as the court is aware, that only came up after the deadline was missed. There's a 90-day statute of limitations for the executor, but anybody else making a claim as a creditor under a will has 180 days. Now, Mr. Landers saw, and I think about day 91 or 92, that he missed this and brought in this other attorney, John Clark, who sent the email to help. And the partnership theory was devised by him only after Landers missed the 90-day statute. And they're trying to think of a way to get all of Joel's claims in and bypass the 90-day statute of limitations for an executor. I believe they even thought about attempting to have Joel resign as the executor. However, there's case law and all that stuff, or all of those things, stopping that from happening. So I wanted to point that out. And this partnership theory did not strengthen his position. His position was already lost. He was entitled to everything, the spousal allowance and the fees. He was entitled to the balance if he was a general creditor. But instead, again, as I said before, he has to settle for half of that. And that's based on, they did come up with a partnership theory, and I think John Clark did do a good job for him based in that situation. But his claims are already lost.
So, had he not missed the statute, wife still would have been permitted to file against the estate.
She would have been able to take against the estate, so which she did anyways. So she would have got the first $40,000, and then the cost of administrations would have come off, and then there would have been a balance of the estate. Now, the spousal allowance under the probate code is not a preference. So anything that she would get after the spousal allowance of $40,000, she takes after general creditors, which Joel Cessna would have been. He would have been a general creditor, and his claims are about $160,000. The balance of the estate was only $83,000, I believe. He would have taken the balance of the estate. There wouldn't have been anything left.
But that assumes that he is able to get around the statute of limitations, so there
Correct.
could potentially have been a resolution that is similar to the one that he reached.
I guess
in order to negotiate taking into consideration a settlement between them.
And is that possible? Yes. But I think my client was divested of that opportunity to make that decision.
But he has the burden to show
that these were loans.
that, well, not only that these were loans, but your client has to demonstrate prejudice. That is what the court found, that found that there was no prejudice.
They just found
no damage.
No damages.
No damage.
No damage, not prejudice.
Okay.
Correct. Also, I wanted to point on no terms. Opposing counsel said there's no terms. There were never any terms. And I'm looking at Mr. Cessna, my client's deposition, which we've quoted extensively on page 3 of our response brief, and I'll just paraphrase, any agreement on terms of repayment of these loans was the question. Answer, just whenever he's able to. What were the terms of the repayment? Whenever he could. So there are terms there. There is conditional language in these loans. When they're speaking about loaning the money, the agreement is he's going to repay when he's able. And we do also need to point out to the court again that this was an unexpected death. His brother died unexpectedly, but he's also the beneficiary, sole beneficiary of his will. So we really think this becomes an issue of when was he able to repay? And that's a jury question, I think, as Your Honor had pointed out there. Does he have to sell his interest in the farm? I think not. I think he's allowed to have a place to put his head and to live. Does his brother have to begin collecting? Is that the condition? I don't know. But that's for the fact finder to determine.
What about after selling the cars?
Well, after selling the car, I think if we look back at the depositions, very little was coming in. And I think Joel's position is he was leaving something for his poor brother to live on. I think about $10,000 or $15,000 a year. So if you sell a car at this auto range business and he makes $100, for instance, or $500, is the condition precedent, the ability to repay, satisfied then? And that money has to immediately go to his brother, who has basically said the terms are when you're able. We would argue that making $500 on a car doesn't make you able to repay a loan. And I think
you have reached the end of your time.
Thank you.
Gentlemen, thank you both for your presentations. The court will take the matter under advisement. We will conference with our colleague and issue a written opinion, which will be sent to both parties. And do check the Supreme Court website as we list our decisions there. Thank you.
Thank you.
Have a good day.